So one of the things that it appears the authors of the Affordable Care Act legislation really tried to do was identify some of the most common industry practices in health insurance and try to provide some regulation around those. So things like if you didn't fill out your insurance forms correctly, that you could your policy could be rejected, even if you're part of an employer. You filled it out incorrectly, you're ineligible for insurance this year, and you can try again next open enrollment period, as an example. I remember from working in a health plan well before the Affordable Care Act, and what I recall was that at least in Maryland, um, there was a path for members to appeal decisions through the state, but there was no federal recourse for appeal. And the ACA was intended to instantiate a process that was clearly defined and a place that people could go beyond the state to the federal level through HHS to file a complaint about, or even sorry, not even to file a complaint, but to appeal an insurance decision. Now, what appears to have happened in reality, I mean, this is just from looking at hhs.gov, is that this stuff was either never really set up, and it appears it never really was completely all the way kind of implemented. And certainly there's no, at least again, just my interpretation reading through the HHS website, that there doesn't appear to be any form of appeal processing at the federal level through HHS currently. One of the other common practices was, according to the way the legislation is read, is that policies could be canceled, and they could be canceled. They use the word frivolous. I put that in quotes. It's supposed to be a little quote right here. So frivolous usually meant, and this is somewhat partly my interpretation as well as what's written, is that if the plan wasn't profitable enough. So if they weren't, and this ironically comes up a lot when we talk about health plans being willing to engage in the healthcare exchange through the ACA and the premiums they charge. So this is front and center of directly related to the article about the Idaho governor, right? So the idea, well, we can't make enough money to satisfy ourselves, make enough of a margin to make this plan quote unquote viable for us. So we're going to not do it. What was not uncommon, or not uncommon enough to elicit this part of the regulation, was that health plans could be dropped right in the middle of a coverage year. Okay. So there's some regulation around that. And also, if you've ever had an employee-sponsored plan, you're familiar with the process of an enrollment period. I think even as students, you may have that. That's so long ago, I don't recall it. But as a student, but I think for you guys, there's an open enrollment thing. You guys can comment if I'm correct on that. But anyway, the way it historically has been in terms of industry practice, there's an open enrollment period, and that's it. So if something happens, like the birth of a child, you historically could potentially have to wait till the next open enrollment period to have coverage for that child. So those are the kind of, when they say special enrollment exceptions, those are the kind of things they're talking about there.